Hi, good morning everybody. Have a nice day. In the previous topic, if any doubt, you can ask to me. If any doubt, you can ask. Okay? I think no doubt in your side. In constitutional law, today we can study the topic state. What is the meaning and nature of state? State includes the government and the Parliament of India, and the government and the legislature of each state, and all local or other authorities within the territory of India or under the control of government of India. State includes government and the Parliament of India, and the government and legislature of each state, and all local or other authorities within the territory of India or under the control of the government of India. Thus, the executive as well as legislative organs of the center and state shall be state within the meaning of Article 12 of the Constitution of India. Article 12 determines whether that institution is state or not. The term government includes a department of the government or any institution under the control of department of the government. Government includes a department of government or any institution under the control of department of government. According to the case PD Supply Company versus Union of India, All India Record 1956, Supreme Court 479, it has been held that the Department of Income Tax shall be state within the meaning of Article 12. In that case, Income Tax Department is considered as state. Next, similarly, in Purushottam Land versus Union of India, Purushottam Land versus Union of India, All India Record 1973, Supreme Court 1088, it has been held that the Forest Research Institute shall be state within the meaning of Article 12. In that case, Forest Research Institute is considered as state. In Star Enterprises versus City and Industrial Development Corporation of Maharashtra, 1990, Supreme Court case 280, it has been held that a private body which is an agency of state may be state within the meaning of Article 12. Here, a private body is considered as state within the Article 12. Next, in Karnataka State Forest Industrial Corporation versus Indian Rocks 2009, Supreme Court case 150, the Supreme Court declared that the Karnataka State Forest Industrial Corporation as a state under Article 12 of the Constitution of India. Here, Karnataka State Forest Industrial Corporation is considered as state. Next, what is the meaning of local authorities? According to section 331, local authority includes municipalities, district boards, panchayats, improvement trust, and mining settlement boards, body of port commissioners under the control or management of municipal or local funds. Local authority will be come under the control or management of municipal or local fund. Next, other authorities. The term other authorities is not defined in the Constitution of India. The courts have to interpret this expression with reference to fundamental rights. According to the fundamental rights, some institutions are considered as other authorities under Article 12. Okay. These authorities which are vested with power to make laws, bylaws, rules, orders or regulations are called other authorities within the meaning of Article 12. The other authorities have some rights for making laws, bylaws, rules, orders or regulations. According to the case Somprakash Lekhi versus Union of India, All India Record 1981, Supreme Court 212, Air India Statutory Corporation Limited, Corporation versus United Labour Union, All India Record 1997, Supreme Court 645. What are the two cases? Somprakash Lekhi versus Union of India and Air India Statutory Corporation versus United Labour Union. The Supreme Court laid down certain principles to determine whether a company or corporation could be said to be an agency of the government or not. According to the following 6 points, the Supreme Court will be consider whether that company or corporation could be said to be an agency of the government or not. What are the points? If the entire share capital held by the government, the entire share capital must be held by the government. Next, existence of deep and pervasive state control. State must have controlling power. Next, state conferred enjoyment of monopoly status. State must have monopoly status for their activities. Next, if the functions of corporation are of public importance, institutions must be function for public. Next, if the functions of corporation resembles government functions. If the functions of corporation resembles government functions. Next, transferring a department of a government to a corporation. These are the 6 points in order to consider whether an institution is government or not, or state or not. If the entire share capital held by the government, existence of deep and pervasive state control, state conferred enjoyment of monopoly status, if the functions of corporation are of public importance, if the functions of corporation resembles government functions, transferring a department of a government to a corporation. According to case LIC of India versus Escorts, All India Record 1986, Supreme Court 1370. The Life Insurance Corporation and the Industrial Finance Corporation were held to be other authorities within the meaning of Article 12. The Life Insurance Corporation and Industrial Finance Corporation will be considered as other authorities within the meaning of Article 12 because they have their own laws and orders. Next, Steel Authority of India Limited versus Sri Ambika Mills Limited. All India Record 1998, Supreme Court 418. Steel Authority of India Limited, an incorporated company fully owned by the Union of India, was held to be state within the meaning of Article 12. Similarly, in Steel Authority of India Limited versus National Union Waterfront Workers, All India Record 2001, Supreme Court 3527. The instrumentalities which discharges public functions and duties under various central and state acts was held to be state within the meaning of Article 12. The Steel Authority will be considered as state because they are fully owned by the Union of India. Next, another case is that the Mysore Paper Mills Limited versus the Mysore Paper Mills Officers Association. All India Record 2002, Supreme Court 609. The Mysore Paper Mills Limited, which was entrusted with the public duty of rural development, in which over 97% of share capital was contributed by state government. In this case, more than 97% of share capital contributed by state government, and also it focuses for rural development. The directors were elected with the concurrence of the government. Directors are elected by government. Was held to be state within the meaning of Article 12. This will be considered as state. Next, the following are not included under the term state for the purpose of fundamental rights. They are Lieutenant Governor of Delhi and others versus V.K. Sothi and other. All in the record 2007, Supreme Court 2885. The State Council of Education, Research and Training, that is SCERT, State Council of Education, Research and Training, SCERT, was not held to be state because neither the government has deep and pervasive control over working of SCERT, nor it was supported financially or administratively. In SCERT, they have no control by government, so it will not be considered as state. SCERT is not considering as state. The following institutions will be considered as state. They are the National Academy of Arts, MP Pradeshik Scouts and Guides Enlisted Society, the Indian Red Cross Society. These three institutions will be considered as state. National Academy of Arts, MP Pradeshik Scouts and Guides, the Indian Red Cross Society. Next, whether state includes judiciary. Whether the state includes judiciary. Judiciary is not specifically mentioned under Article 12 of the Constitution of India. Judiciary not specifically mentioned under Article 12 of the Constitution of India. In the United States, a judicial decision is included in the concept of state action for the purpose of enforcement of fundamental rights. Premchand Garg versus Excise Commissioner, HPAR 1963, Supreme Court 1996. The Supreme Court of India included the judiciary while exercising its power of rule making comes within the meaning of state. But while performing its judicial functions, it does not cover within the meaning of state. The Supreme Court of India concluded that judiciary while exercising its power of rule making comes within the meaning of state. But while performing its judicial functions, it does not cover within the meaning of state. A judiciary is not specifically mentioned under Article 12 of the Constitution of India. In the United States, a judicial decision is included in the concept of state action for the purpose of enforcement of fundamental rights. We can discuss what are the points to remember. Article 12 of the Constitution of India defines state. Article 12 of the Constitution of India defines state. Which article defines the state? Article 12. Next point, local authority includes municipalities, panchayats, etc. Local authority includes municipalities, panchayats, etc. Next, Supreme Court held that IT department, forest institution shall be state. IT department and forest institution shall be state. Next, judiciary while exercising its power of rule making is a state. Judiciary while exercising its power of rule making is a state. That is other authorities. Next, to determine the entire share capital held by the government. To determine the entire share capital held by government. State the entire share. If the institutions entire share capital held by the government, that will be termed as state. So what are the points to remember? Article 12 of the Constitution of India defines state. Local authority includes municipalities, panchayats, etc. Supreme Court held that IT department, forest institution shall be state. Judiciary, while exercising its power of rule making is a state. To determine the entire share capital held by the government. Okay, those in this case, many other cases we also considered as state, that is Mysore Paper Mills Limited, Steel Authority of India Limited, LIC of India, according to other authorities, LIC of India, and Life Insurance Corporation, that is Industrial Finance Corporation, the National Academy of Arts, MP Pradesh Scouts and Guides, Indian Red Cross Society, etc. Okay. Next, we can come into the questions. First question is, what is state under the control of under the Article 12 of the Constitution of India? What is state under Article 12 of the Constitution of India? Next, define the term state in the light of fundamental rights. Next, explain the scope of state under Article 12 of the Constitution. Next, explain the concept of state with reference to Article 12. Next, define state and examine the different authorities under state. Once more, first question is that what is state under Article 12 of the Constitution of India? Second question is that define the term state in the light of fundamental rights. Third question is that explain the scope of state under Article 12 of the Constitution. Fourth question is that explain the concept of state with reference to Article 12. Fifth question is that define state and examine the different authorities under state. Okay, next we can discuss one problem and solutions related to state. Problem is that the Army Welfare Association established Army School at Delhi for the purpose of providing quality education to the children of Army and ex-servicemen. The Army Welfare Association School was established, registered and run purely by the donations and contributions made by the members of the association. The office bearer of the association were the commanding officers of the army. X. A teacher in the said school was terminated as her performance was unsatisfactory and also indulged in indisciplinary activities. X filed a writ of mandamus for reinstatement on the ground that the Army Welfare Association was maintained by Army. Decide. Issue of this problem is that whether Army school comes within the definition of state? No. Whether the Army has control over the school? No. Whether the termination of X is valid? Yes. Whether X is entitled for reinstatement? No. Whether the writ petition of X is maintainable? No. Rule related for this problem is that Article 12 of the Constitution of India. The term state includes the government and Parliament of India and the government and legislature of each state and all local or other authorities within the territory of India or under the control of the government of India. Thus, the executive as well as legislative organs of the center and state shall be state within the meaning of Article 12 of the Constitution of India. Hence, every school cannot be regarded as state under Article 12 of the Constitution of India, and a writ petition will not lie against a purely private education institution not receiving funds from the government or a government agency, as it cannot be deemed to be an instrumentality of the state. Application of this problem is that Army School versus Srimati Shilpi Poll 2005, Electronic Supreme Court 342. The Army Welfare Association established Army School at Delhi for the purpose of providing quality education to the children of Army and ex-servicemen. The Army Welfare Association School was established, registered and run purely by the donations and contributions made by the members of the association. The office bearer of the association were the commanding officers of the Army. X. A teacher in the said school was terminated as her performance was unsatisfactory and also indulged in indisciplinary activities. X filed a writ of mandamus for reinstatement on the ground that the Army Welfare Association was maintained by Army. It has been held that the appellant is not state under Article 12 of the Constitution of India. Hence, the writ petition itself was not maintainable. According to one case is that Srimati Rajni Sharma versus Union of India 1994, Electronic Supreme Court 211. It has been held that the Army School run by the Army Welfare Education Society is state under Article 12 of the Constitution. Next case is that Abu Said versus Principal Madrasa, Tul Islah, Sarai Mer, Assamgarh 1998. It has been held that a writ petition lies even against a private education institution, since the education institution is discharging a public duty of imparting education, which has been held to be a fundamental right by the Supreme Court. The court did not agree and opined that every school cannot be regarded as state under Article 12 of the Constitution of India, and a writ petition will not lie against a purely private education institution not receiving funds from the government or a government agency, as it cannot be deemed to be an instrumentality of the state. We can see one case also is that Integrated Rural Development Agency versus Ram Pyare Upadhyay 1955 Supreme Court case 495. It has been held that the Integrated Rural Development Agency, which was a registered society not constituted under any statute and did not function by or under the authority of the government, was not stayed under Article 12 of the Constitution of India. Next case is that Chandramohan Khanna versus National Council of Education Research and Training and others. On the record 1992, Supreme Court 76, it has been observed that Article 12 should not be stretched so as to bring in a very autonomous body which has some nexus with the government within the sweep of the expression state. A wide enlargement of the meaning must be tempered by a wise limitation. It must not be lost sight of the fact that in the modern concept of welfare state, independent institution, corporation and agency are generally subject to state control. State control does not render such bodies as staged under Article 12. Then we can come into conclusion of this problem is that in the instant problem, the Army Welfare Association School does not fall under the definition of the state. The Army has no control over either the administration or the finances of the school. The termination of X is valid because of the unsatisfactory behavior and indiscipline, and therefore X is entitled for reinstatement. The writ petition of X is not maintainable. So that Army school was run by the finances provided by the members of that institution. So the writ petition of X is not maintainable. Okay, thank you all. Thank you for watching. Please try to answer the questions which are provided in the topic. Okay. Bye.